sure you understand that after today, I will not accept this plea agreement. Once your case gets put on the trial docket, it goes to trial, or if you change your mind, you can plea open to the court or to some different plea agreement unless there is new information that your attorney or the district attorney's office receives. Do you understand?
Mr. Sherman has passed vacantly.
Good.
No response, Your Honor.
All right, his bond will be forfeited for non-appearance and reset at $100,000. He did call, say he's having issues. If he gets here late, then I'll obviously recall that bond forfeiture.
And Judge, like I
You've
said,
got Karis oh, go ahead, I'm sorry.
he did call this morning. When I tried to call him back to his house number, he was already gone, so I'm assuming he is trying to.
Maybe on his way. Okay, thank you. And then you've got Karis Antoine, Mr. Lewis.
Yes, ma'am, Judge.
We're waiting on CPS records in this case.
Are we? Okay. You're Karis Antoine? And this is cause number 24 DCCR 1878. It looked like I did sign an order back in May for CPS records.
You did, Judge, and we contacted them this past week asking for an update. They hadn't gotten back with us yet.
Okay.
I even had Mr. Hoffpower call because he's used,
Right.
and he did that for me at the end of the week, and they hadn't replied yet.
All right, we'll reset that just another 30 days. If you'll make a sticky note for us, we'll try to contact them as well and see if we can, sometimes that helps to get things moved
So
along.
reiterate what said, I spoke to them by email, Stephanie.
Okay.
Hines, but we still haven't received those records.
And she didn't give any update on when we
She
could
didn't give me
expect
an
them?
update, But it was Friday.
Okay.
I got last contact.
She's usually pretty responsive.
Yes.
All right, so Mr. Antoine, stay in touch with Mr. Lewis. He'll let you know once he gets that information so you can go in and go over it with him. And then we'll try to get an announcement, hopefully if we get that before the next court date.
Thank you, Your Honor.
Thank you.
And off the record, I'll show you their email reply to Mr. Hoffpower's voicemail. Sound about right? Didn't it, Sophie?
He's giving you a hard time without saying anything.
I know, I understand. It's okay.
You can handle it.
Next game, I'm good.
Mr. Rojas, you've got Carnell Beard. Good morning, Mr. Rojas.
Morning, Your
Good morning, sir. You Carnell Beard?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Are we going on count one? Oh, no?
No, ma'am, we'll go
Okay,
on. Everything.
okay, let me, all right, and he'll waive the formal reading of the indictment.
He will, Your Honor.
Mr. Beard, you're charged with the third-degree felony offense of collision involving serious bodily injury from September 28th of 2024. Your indictment also alleges that you were previously convicted of attempted murder, second-degree felony, August 30th of 1999. And after that was final, you were convicted of possession of a controlled substance, a first-degree felony. Well,
Judge, I'm
do we
looking
just
at
need
the
to go on one, or
Let's
is
just
that?
go on one, because I'm looking at the dates, and they do overlap, so it would not make them
It
habitual.
wouldn't,
It'll
so it
be
makes it a second-degree felony.
Your Honor.
So what that means, sir, is that the punishment range in your case would be enhanced to that of a second-degree felony, which is 20. Do you understand?
Yes, ma'am.
And how do you plead to that charge?
Yes.
And is that prior offense true?
Yes, ma'am.
Okay. Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 10-year deferred adjudicated probation. There would be a $1,000 fine, and there would be restitution ordered as determined between now and when we come back for pre-sentence, through a pre-sentence report. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Beard is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case. We'll also get that restitution amount determined, and then we'll come back later for sentencing. When you're on your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right there. All right, we'll see you back at sentencing.
Thank you, Your Honor.
And then you've got Zachary Turner, Mr. Rojas. Good morning, sir. Are you Zachary Turner?
Yes, ma'am.
And this is 24 DCCR 2197. And Mr. Turner, you're charged by indictment in this case with the first-degree felony offense of fraudulent use or possession of identifying information from April 22nd of 2024. Your indictment alleges that you were previously convicted of unlawful possession of a firearm by a felon, a third-degree felony, September 29th of 2014, which means that this, for punishment purposes, would be enhanced,
15
but,
and 99 is the way we indicted, Judge.
right.
Given the rejection of the state's offer today, I believe we can make him a habitual, and I will be filing a habitual offender notice in this case.
So, and you've gone over that with Mr. Rojas, correct? And so I want to make sure you understand that if the state files that notice of enhancement with another prior offense, which I would assume you have since the one I see is an unlawful possession of a firearm by a felon, that means that if you go to trial and you're found guilty, the minimum punishment would be 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 15-year term in the institutional division of the Texas Department of Corrections. And I would assume that would be going on count one only.
That's right.
And so you have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Turner, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? So, Mr. Rojas, you're released. Mr. Turner, if you'll just have a seat here in the courtroom, I will appoint someone. The clerks will call you up in just a minute with that information on who your lawyer's going to be. I'll also want to make sure you understand that after today, I will not accept this plea agreement. Once your case gets put on the trial docket, goes to trial, or if you change your mind, you can plea open to the court or to some different plea agreement unless there is new information that your attorney or the district attorney's office receives. Do you understand?
Yes, ma'am.
Okay. If you'll just have a seat, she'll call you up in just a minute. Mr. West?
What unfolded in this courtroom was not chaos or theatrics. It was the quiet procedural weight of the justice system pressing down on several lives at once. No shouting, no viral outburst. Just the steady rhythm of consequences being explained, acknowledged, and in some cases resisted asterisk. It began with clarity. The judge made it unmistakably clear that once a plea offer is rejected, the door does not stay open forever. This wasn't a warning wrapped in anger. It was a matter-of-fact reminder of how the system works. Is placed on the trial docket, the rules change. The defendant can go to trial, plead open to the court, or accept a different agreement. Only if new information emerges. That single explanation set the tone for everything that followed. Informed choices, real stakes, and no room for confusion later. Asterisk when a defendant failed to appear. The response was firm but measured. Bond forfeited, reset at $100,000. Yet even there, the court left space for reality, acknowledging the call, the possibility of delay, and the willingness to recall the forfeit if the explanation proved legitimate. It was a reminder that while the system is strict, it is not blind. Accountability and discretion can coexist. Risk the courtroom then shifted into a quieter, slower gear, one that often goes unnoticed, but matters deeply requests for records follow-ups. With outside agencies, 30-day resets, email sent, calls made, sticky notes placed. This is the unseen side of justice delays not caused by drama, but by bureaucracy. The judge encouraged communication, patience, and preparation, emphasizing that information. Especially records tied to family or child services can shape outcomes. Stay in touch. Review the documents. Be ready to move forward when the pieces finally arrive. Then came a case heavy with history. Carl Beard stood facing a charge that carried serious weight, collision involving serious bodily injury. But the present was inseparable from the past. The indictment laid it all out: prior convictions, including attempted murder and a controlled substance offense. The legal discussion that followed wasn't about shaming. It was about accuracy. Dates mattered, overlaps mattered, and because of those details, the enhancement shifted. What could have been treated as something more severe was clarified into a second degree. Felony enhancement? Risk. The judge explained the punishment range carefully, making sure understanding came before anything else. Each question was deliberate. Did you plead freely? Did you understand the documents? Did you review them with your attorney? Do you understand that accepting this agreement means giving up the right to appeal? Each "yes, ma'am" wasn't just a response, it was a confirmation that this decision belonged to the defendant, not the system. Asterisk, the agreement itself reflected balance. 10 years of deferred adjudication probation, a fine restitution to be determined after a pre-sentence report. Not freedom, not prison responsibility. And before moving on, the judge addressed something many overlook but cannot escape: immigration consequences. One plea can change everything beyond the courtroom walls. Asterisk, competency was confirmed. Evidence was admitted, and then importantly, sentencing was not rushed. The judge reset the case for a pre-sentence report, signaling that understanding the person mattered as much as understanding the charge. Talk to probation on your way out, she said, not as a threat, but as the next step in a process that now belonged to the defendant to navigate. Then came a turning point, one defined by risk. Asterisk, Zachary Turner faced a first-degree felony involving fraudulent use or possession of identifying information. But the real gravity lay beneath the surface. Prior convictions meant enhancement, and with another notice filed, the potential punishment range exploded from a minimum of 25 years to life in prison. The judge did not soften this reality. She laid it out plainly. If the state files the habitual offender notice and the defendant goes to trial and loses, the consequences are devastating. This was not pressure as transparency. The plea offer was also clear: 15 years in prison, count one only. A defined outcome versus an unknown, potentially irreversible one. And yet the defendant rejected it. Risk that moment carried no drama, but it carried weight because rejecting a plea is not defiance. It is a gamble. The judge ensured the defendant understood every option, every consequence, every fork in the road. Only then did she move forward. Asterisk, counsel was released to allow new representation. Someone who could prepare for trial more quickly. The system adjusted just as it is designed to do. But before letting the defendant sit back down, the judge returned to the same warning. That opened the session. After today, this plea agreement will not be accepted again. It's a trial, open plea, or something new if new facts emerge. No rewinding the clock. And that is the quiet truth of this courtroom. Justice here was not loud. It was careful. Each defendant was given time, explanation, and choice. But choice does not erase consequence. Some accepted structure and supervision. Others chose uncertainty, and the court, steady and composed, recorded every decision. This is how lives pivot, not in viral moments, but in measured questions, signed documents, and a final unmistakable understanding. Once you walk past a certain point, there is no guarantee the door behind you will ever reopen.